The Ruto Sang defense teams have lodged an appeal against the use of the controversial amended Rule 68. The appeal judges will as such have to dispense with the matter. The trial chamber judges as well will have to give their decision on whether they will apply this week's ASP reaffirmation that the amended Rule 68 cannot be used retroactively.
Of course, it's up to the court. Any matter that is already in court cannot be handled otherwise. ASP is a parliament, it's an assembly of state parties. It acts like a legislative body. It makes the law. That law is enforced by the court. The point we went to do in The Hague was that we went for a battle to provide a clear affirmation of what the rule meant in 2013. Now, after doing what we did, it's up to the courts to now apply the rule.
For me, I await now the decision of the court. It's not for me to say. But I think when you look at how also the courts performed during Rule 134.4, remember we again went through an ASP assembly. That is where we agreed. And the next day, the same thing happened. That's when the courts also agreed with us.
When they took the decision, with presiding Judge Chile Eboe Osuji dissenting, the judges said, quote, that the chamber notes that the text of the amended Rule 68 does not contain any express time limitation as to when it would apply. The understanding of most critics and the civil society being that since the reaffirmation was adopted as part of the ASP report, there was no express definition to the concern on whether it would affect the decision already taken by the judges. Gitobu Imanyara says, quote, the view being propagated by Jubilee that Kenya won is not accurate. The amendment of that year did not bar prior recorded testimony. It actually introduced it at instigation of, among others, Kenya. He goes on to say, unlike a formal resolution, a report does not impose obligations either on the court or state parties. End quote. Like Gitobu, some members of the civil society argue withdrawal of Rule 68 does not stop the court from admitting Rule 69. That rule says that the prosecutor and the defense may agree that an alleged fact, which is contained in the charges, the contents of a document, the expected testimony of a witness or other evidence is not contested, and accordingly, a chamber may consider such alleged fact as being proven unless the chamber is of the opinion that a more complete presentation of the alleged facts is required in the interests of justice, in particular the interests of the victims.
The president now is to write to the ICC judges that you cannot and must not use recanted evidence retroactively in the case against William Ruto and Joshua Arap Sang. Ule alikuwa anangojea itatumika, tunamwambia ameze wembe.
The use or lack of it of Rule 68 in the Ruto Sang case is a decision that now lies with the Hague Court judges. Jackie Maribe, Citizen Weekend.